Thank you, colleagues. We are about to start the program now. In our midst, we have our acting JP Tlangulela, who will give us a few words of welcome. Thank you. Over to you, AJP.
In defense of me, good afternoon. In defense of me and in defense of my division, I have to make this statement. For an occasion as august as this one, where the son of the soil, Justice Petse, is the center of attraction, one would have preferred to be invited on time. I got to know about this event almost a day before today. I beg your pardon. That's not the culture of Mbenenge. Mbenenge says, when something has to be done and the date is set, you must prepare. I would have prepared better, but I'll do my best to do what I can. Because Mvuzono Jesse has taught me a few lessons about how to do the job that I'm about to do. Thank you very much. I would have been given a list of persons to introduce before we kick off with the proceedings. And I hope that that is still going to be done. But for now, allow me to say all of you are welcome. In particular, Justice Petse, we say welcome to WSU Justice Petse. I will not, thank you very much. And in doing so, I must also extend my heartfelt, let me say, acknowledgement of people who have mattered the most to Justice Petse. I've got the lineup there of justices from the Supreme Court of Appeal. I've got the lineup there of justices from the Constitutional Court. I've got a lineup there of important persons like Berry Matolo. I've got a lineup there. You know, there's everybody here. You know, our teams of attorneys, our teams of advocates. Of course, I must mention the WSU community itself. We are elated to have been permitted to stand here this afternoon to say a few words. All of you are welcome. Thank you very much.
Thank you, AJP, for those warm words of welcome to our delegates. Comrade delegates, honorable guests, we are now proceeding to the next level of our program. As indicated, we've got 3 segments to deal with. We are about to get to the final stages of part A of our program. And I would like to call to the stage Comrade Tia, who's going to moderate the panel discussion. Comrades, we have time limitations. We have to break at some point for lunch. The speakers have been allocated 15 minutes for their presentations, and thereafter the members will be, or the floor will be open for delegates to engage with the speakers on their presentation. So all in all, we would have 45 minutes or so. Thereafter, we would break for lunch. But for now, I call to the stage Comrade Tia, who is going to moderate this session. Thank you.
Thank you very much, Comrade Deputy President. Let me also take this opportunity to stand on the protocol already observed. As a junior, I don't want to make a mistake of mismatching authority in the process of acknowledging people. It's better and best that I stand on the protocols already observed. Be that as it may, we are proceeding with the program. I would request Justice Langa and also Advocate Skakane SC to come forward and take the seats as they are going to present for us on involving justice, the past, the present, and us. I don't know. Yes, we'll use this one. Thank you. Before Justice may start, I would request those who are junior as I am to have pen and paper so that they are able to take notes and also to run away with them, because this session has to do with also teaching. So we have to learn. It's not only about telling us about the future, the past, and the present, but also to tell us, to give us wisdom on a number of issues that has to do with the law. Kuyacelwa ke i-Nissan engu-HP 58 GZ GP ne-VW JJ 82 SV GP ne-Toyota engu-FVB 404 EC uba zivule indlela, kuthiwa zivale indlela. Iyacelwa kwabanikazi babo babakhawuleze nje bathi che so that kukwazeke into yoba sizoqhubeleka kakuhle without any things that will disturb our program.
Wayithoba kakhulu ndenza mfutshane kakhulu. Ndiyadlala i-right kanye mfutshane. Good afternoon to everybody gathered here today. I will not again repeat the recitation of the protocol. I have titled my address, "The Invidious Position of Lawyers with a Conscience During Liberation Struggles." At the best of times, the pursuit for justice for a legal practitioner can be difficult and elusive. Under oppressive systems, this quest is rendered near impossible. In the main, this brief address will give a historical perspective of how practitioners navigated legal practice during the highly oppressive apartheid legal system. Maybe I should not have said in the main, because effectively it is historical. The address also deals with the invidious position of lawyers who were employed within the government system, who were not only politically conscious, but were also underground activists. And I've chosen to make this address more of a narrative about specific people and events than an academic discourse. So, zibekeni phansi iballpen ezi. Crucially, the battles waged by those I mentioned in the narrative, some like mine, minor, were all calculated to add something towards the attainment of democracy. The split-lived reality of a lawyer and quote-unquote outlaw was not uncommon for legal practitioners standing against the apartheid regime. In fact, during apartheid, this was true not only of legal practitioners, but also of some legal officers within the government service. Amongst them, I can count the late Mr. Themba Momoti, a prosecutor who was detained for political activities in the Transkei. He became Budumisa Ntsebeza's client. Sayimngcwabeni wakhe noBradibe siye epatini. Sasilele kulo party for most, emngcwabeni rather for most of the time. uBradibe samnyaxa xa sekufuneka eyothetha. Awuke bekhona apha eca kwami. I can also add to the count people like then magistrate Bantu Bonke Tokota, who, although not openly political, used to stand his ground against the expressed wishes of senior homeland government functionaries. It was not uncommon at the time for these functionaries and sometimes the homeland leaders themselves to convey to judicial officers what outcomes they desired in highly sensitive political cases. Where it was warranted, Magistrate Tokota readily decided such cases against the wishes of the homeland operatives at great personal risk. Another example was a senior regional court prosecutor whom we nicknamed Gunman, his surname being Gancho. He was a firebrand underground political activist. I hope firebrand and underground are not contradictory. Such was Gunman's activism that he and many others were detained without trial under Transkei security laws for about a year. When they eventually appeared before Magistrate Joseph Lukwako Mugerwa at the Mthatha Magistrates Court, the prosecution was not ready to run the trial. Imagine not ready after a whole year of detention. The prosecution asked for a postponement. Mr. Lukwako did the unthinkable. He refused the postponement and struck the case from the roll. I say the unthinkable because it would have taken a lot of guts to make such an order in a matter in which then Transkei President Mr. Kaiser Matanzima had a personal interest. The case was in B Court. If I'm not mistaken, B Court has 4 exits. The minute the order was pronounced, the detainees jumped over the dock and ran in all 4 directions towards the exits, exited and vanished. Security police, who must have been taken by surprise, could not do anything. I know all this because at the time, I too was a junior magistrate at the Mthatha High Court, and Joe Lukwako was a close friend of mine. Gunmen left for exile. Having mentioned Joe Lukwako's extremely brave act, I must add him to the list of legal officers within the government service who were fearless of the system. I am going to mention Joe Lukwako later. No, I've deleted that part because of time constraints, so I won't mention him again. I cannot but also mention retired Constitutional Court Justice Chris Jafta. When he was a prosecutor at Cala in the Eastern Cape, he refused to take instructions from the security police on how to prosecute cases involving so-called emergency regulations. He was detained and subjected to intense interrogation by the security police. Subsequent to that, his authority or delegation to prosecute was revoked and he was demoted to the position of administrative clerk. So, the stands some of us took came at great personal cost. I do not claim to have been any Themba Momoti, Bantu Bonke Tokota, Gunman Gancho, Joe Lukwako, or Chris Jafta, but I hope you will find a rendition of at least one of the things I did whilst I was a junior magistrate of some interest. Having grown under the wing of people like Advocate Dumisa Nsebeza SC, the inaugural president of Nadel, Butoli Madala, a Mtata advocate and later Constitutional Court Justice, Tatu J.B. Vusani, a Mtata attorney and former Robben Island inmate, and many others, there was no way I could not have been politically conscientized. In fact, the seed of conscientization started during my days at this very university, then known as the University of Transkei. Although I had known these giants for many years before, I got very close to them when we were members of a local progressive lawyers organization called Mtata and Districts Lawyers Association, commonly known as UDLA. Amongst its officials were Budumisa, who was its chairperson, the late Butoli Madala, deputy chairperson, Ubudumkululi Manliwa, its secretary, me, the treasurer, and Utatu Vusani. It was from this body that much later I transitioned to Nadel. It was when I served my bursary obligations within the Department of Justice that I first came to contact with these firebrand progressive lawyers. It did not take much for me to follow them and join UDLA and later Nadel. This was because, of course, I joined Nadel after the split. This was because from an early age, I had a rebellious streak. For instance, during the University of Transkei strike of 1984, the president of the Student Representative Council, Mr. Zamikaya Mbalu, Mr. Toby Lebam, a close friend of mine, who later became an Umkhonto Wesizwe soldier, and the late Mr. Batandwa Ndondo, who was later brutally gunned down by the South African and Transkei Security Police, were amongst those who were in the forefront of the strike. As a result, they were targeted for arrest by the Transkei Security Police. I had completed my first law degree the previous year and had begun working for the Department of Justice. One evening, my friend Tobile, Zamikaya, and Batandwa rocked up where I lived at Ikwezi Township, Mtata. They asked me to hide them for a while. I was only too happy to, and my cousin at whose place I lived obliged. They lived with us for a week or two. I would transport them by night wherever they wanted to go by motorcycle. The most notorious of the security police at the time were a Mr. Dengana and a Mr. Boy. Apologies to them and their families for saying they were notorious, but they were. They used to come to Mtata Magistrates Court where I worked. Because I was a magistrate, albeit very junior, they would refer to me as Mhlekazi, meaning sir, when they met me in the corridors. I remember how I used to think, ukuba nje uDengana noBoy bangaze bazi ukuba ndigcine obathandwa bangandithena. If Dengana and Boy were to know that I am harboring Batandwa and them, they would castrate me. I think it was because of the rebellious streak in me that I was not in the least deterred. I did a few more other things, but because of time constraints, I will not get into those. Few things pain and nauseate me more than the uninformed idea that by working for the Department of Justice during apartheid times, like some of us did, we were conformist. In my case, and that of the few I mentioned earlier, and many others I know, nothing could be further from the truth. And the narratives I have given amply demonstrate this. Coming to activists, practicing lawyers, retired Constitutional Court Justice Albie Sachs talking about himself when he was a practicing advocate, aptly captured the predicament of activist lawyers under the oppressive apartheid regime. He said, "The fact is that for much of my life, I lived simultaneously as a lawyer and as outlaw. Anyone will know how split the psyche becomes when you work through the law in the public sphere and against the law underground," close quote. In confronting this predicament, progressive or activist lawyers practicing during the apartheid era were forced to grapple with and fight the unjust system, aiming to dismantle it through covert and overt political means, while overtly operating within its bounds on the legal front. Krishi's address gave meat to what I have just said. Some, like Mr. Griffiths Mklenge and Mrs. Victoria Mklenge, were killed by apartheid operatives for their role in this fight. In their court battles, these lawyers had to be innovative. I am proud to say that a substantial number of those battles were fought from this very town, Mthatha. The law firm that spearheaded the charge was Sangoni Incorporated, then known as Sangoni Partnership, under the leadership of Mr. Themba Sangoni, who later became judge president of this very division. What a lawyer. I remember that I used to say to friends and acquaintances that if I were ever to need an attorney, Themba was the obvious choice. Few know that at the time, Sangoni Incorporated was South Africa's largest black law firm. Hayi firm yaseGoli, Pitoli, Kapa, Durban, ifirm yalapha eMthatha. Justice Xola Petse, whom we are celebrating today, and Putumisa Ntsebeza were among the partners. That law firm was a powerhouse in the fight against apartheid laws through legal means. But I would imagine there must have been some illegal means underground as well. Last night I asked Putumisa, "Ake andiphe some of those." Use wandiphe as legal kuphela. Its reach extended throughout South Africa. It briefed senior and junior counsel from all over the country. The late Pius Langa, who later became South Africa's Chief Justice and was a long-standing president of Nadel, the late Thembile Skweyiya SC, Marumo Mwerane SC, Justice Poswa SC, Dikgang Moseneke SC, and many others regularly got briefs from Sangoni Incorporated. This was not to do cases only in Mthatha and surrounds, but all over South Africa. Many a young junior of the time cut their teeth on regular briefs here in Mthatha from Sangoni Incorporated. I can mention Ish Semenya, now SC, Vincent Maleka, now SC, Tsepo Sibeko, now SC, Chris Jafta, the retired Constitutional Court Justice, Selby Mbenenge, now this province's judge president, me, and many others. I am proud to have held watching briefs from Sangoni Incorporated together with Pius Langa in respect of so-called recalcitrant witnesses. Most of these battles were fought in the criminal and administrative law arena. I should not be heard to suggest that only the Sangoni Partnership waged this admirable war, not in the least. Many other law firms throughout South Africa did a sterling job on this front. Counsel also played a significant role, especially in those matters that went to the High Court, as attorneys did not have a right of appearance at that time. Coming to the need for creativity in the fight against apartheid laws, I have a number of examples of decided cases. When preparing this address, I meant to deal with these examples one by one. Because of time constraints, I will not do so. Let me just say, the examples I have on administrative law were so innovative that to the uninitiated, they might have sounded like legal sophistry. They were not. They had a basis on creative and sound legal principles. Just one example is where arguments led to courts, in particular Judge Did Court, to come up with a principle that managed to free detainees in circumstances where some thought that was impossible. Some thought because of how detention powers under security legislation were framed, not much was required beyond the whim of the detaining police officer. Didcot J and a few others who followed him held that the open quote reason, close quote, to detain could not be that of the officer. Rather, the reason had to be objectively ascertainable, a far cry from the subjective whim of the detaining police official. Of course, what informed this was the creative arguments of our activist legal practitioners. I said mine would give a historical perspective, a perspective which, although focusing on the evidence of only some lawyers, was at the center of the fight for democracy for which good Pius Langa spent his entire adult life. I leave it to my co-panelists to deal with the present and future, possibly from a totally different perspective. I hope he has not too left this to me. Suffice it to say, there are numerous battles still to be fought by lawyers. The plane on which these battles must be waged may have changed, but we are far from living in a perfect world. I thank you all.
Thank you very much, Justice, for those profound words. I hope the future is grasping properly what is being said, and it is clear in my mind that if you do not participate in activism, then we will not produce a proper lawyer out of you. And unfortunately, Justice Madlanga, nowadays we are leading a profession that has apolitical lawyers. That is very sad. That is why even when you call a meeting, you will not find more than 20 attorneys in attendance. Even for advocates or attorneys, either it's Nadel or BLA, it's Wild Coast, it's Transkei, or what, but you will find less than that, unless you are going to call Letshwalo from RAF, then they will come. But if you want lawyers to come and discuss the future of the profession, then I am worried. This then takes me back, Comrade Makangela, to a day when Justice Mbenenge, we were looking for a JP. We then approached Justice Petse. We went to Savoy. We had a meeting with him. I was the chairperson of the branch at the time. He listened and listened and listened and said, you know why I'm amazed? He said, no, Justice, what is the problem? Why are you not with other young boys of your age? It's on a Friday, you are busy telling me about the future of the profession, what type of a judge are you looking for, what type of a division are you looking for? Why are you not somewhere enjoying yourselves? We said, hey, Judge, we we are concerned about the profession. It saddens me, Justice Mbenenge, in our division, when we moot law in our corridors, and attorneys prefer a white judge than a black judge, then it means there is a problem that needs to be addressed. And also, I'm very happy with the words by yourself, Justice Madlanga, about the past. I listened very carefully to the interview of Justice Dokota when he was telling Julius about what he did in Transkei, and he told him that if you were there, if you were going to run, let me tell you what I did. I received this message from the authorities of the time. They said, refuse bail for these boys. He went to my chamber. There was no case. Some struck the matter off the road. You were going to run, Julius. And I always laugh at that interview. Also, I must, before I call you Advocate Skakane SC, there were claims that were made here by speakers who came. I want to also claim Justice Petse as an Anglican, and also claim Justice Jolwana as an Anglican. But unfortunately, you know what we do in Libode? We decided to allow Kokolweni, Kumbu, and everyone to take over Mthatha. We are there in Cape Town. Judges from Libode are in Cape Town, and maybe I will be getting an acting stint as a magistrate that side, even myself. We take Cape Town, we love Cape Town, and then we allow Kokolweni and Kumbu, Mount Frere, Nkanduli to take over the site. Let me then welcome to the podium. He is a revolutionary. You will hear even his arguments either in court or in a memorial lecture. I am always very excited to listen to him. Advocate Skakane SC, when he articulates anything or any principle of law, because it always carried a context of equality and why as black people we must rise. Over to you, Advocate Skakane. Thank you.
Unfortunately, I can't claim anyone in the room to come from Soweto or Bulwa, where I was born. Good afternoon, ladies and gentlemen. There are so many people to acknowledge, not just because they are judges or senior colleagues, because there is something very refreshing about going to court. And you see judges, Ntlangulela, Judge Madlanga, Judge Chikri, Judge Bokwana, Judge Mpahlele, Judge Poyo Dlwati, Judge Petse, and all of them as a black lawyer. It's not just about law, it's because it's important to get into an environment that has people like you. Abo put Selby, Abo put Dokota. It's an assuring experience for people who come from a settler colonial logic. And it's important because we talk about big things. Ute put Russell, Ndimsambiza put Russell now, even now. Mboniluzela Pagim, before he spoke, he got in when his deal analysis academic. And I've never been able to say no to them. I don't know. Just say, what in Uzandambisa Pitol. Joburg and Pretoria are distances apart, and that was on Ambisa Pundun Buis. But ladies and gentlemen, I thought you've been told a lot of history. And Put Russell and I decided that he will deal with that history, most of which you know, about where we come from, about what kind of experience they've had. I'm just lucky that most of these lawyers mentioned today particularly Pius Langa, who was really my dad, and Victoria Mkenge. These are lawyers who released most of us. So I was a teenage detainee, and basically it's these lawyers. Krish Govender is here, and many people, and Judge Desai is here. These are people who captured the intellectual tradition, which is anti-colonial at a time when it was not to be done. I want to talk about a couple of things. One is the topic is justice and equality. Having greeted everyone and all protocol observed, and all of you I recognize. I want to start with what Pius Langa said, and I'm going to tell you what Bram Fisher said, and then I'm going to tell you what a young man who was about to be hanged called Ken Saro-Wiwa said, and then I'll tell you a story by Friedrich Nietzsche in 1881 about what you must do now and for the future. But before I start, let me give an example of what we need. The judges that are here, the race of the judges that you see today tells you what's still happening in the judiciary. Judge Petse has been around for years, probably one of our top judges in this country. Look at the complexion of the judges that decided to come and acknowledge him. There's still a lot to be done. But to give you an example, one day, and I think the judges will know this, whenever we come to court, we profile you. So I was profiling Judge Petse to appear before him in the Supreme Court of Appeal. And many judges here, I've had serious, rigorous, but comfortable engagements with them. And I said to Brady, gee, this Petse, what should I know about him? And Brady says, there is no human being that's as hardworking as Judge Petse. What you will get is a human being who wants no nonsense but fair. And I went to court, and a particular white judge completely harassed me in front of Judge Petse for no apparent reason except the history that Judge Petse didn't know. And when this judge had harassed me for 5 minutes, cross-examining me, Judge Petse stopped him because it was harassment of a white judge, former apartheid prosecutor, taking his anger on me. And the judge that was black in the room protected me. The same that happens with Judge Madlanga. And Judge Chikri, I argue vigorously, and he realizes it's a heated debate. And as I drive home, he usually phones and says, "Wetin, all right, Masani?" And I say, "No, I'm good. I'm good." And so it's all I can tell you, many stories. But these stories are not just personal. They're about what justice is, what fairness is. And Judge Petse, before I forget, I think when people think I'm controversial about what I say about judges, I actually mean one thing. A judge should be like you. That's all. A judge should be a human being. You need two things to be a judge. Largely, it's law. All of us can study law, so all of you can be judges. But not all of us can be good, just human beings. And 60% of being a judge, that's all it's about. What I thought I should tell you about today is what Judge Langa said. Because justice and democracy, these are all Greek terms that we can trace to Plato and Aristotle, to the book by Plato called The Republic. We can talk for a long time about what they are, but they are contextual. All of these are historically and culturally contextual. Justice is not a term that can be used without the historical and cultural context of that country. And so they are never objective definitions because they depend on each country. And what are the conditions of our country? The condition, I brought this book to show you one thing, which I think is the challenge. It's called The Death of Truth, because that's what we face and many other deaths. C.J. Langa and Bram Fisher both lived the life of a dissenter. Because justice and democracy can never emerge if there are no dissenting voices. That's what they're about. And both of them live the life of a dissenter, the one who makes a clarion call to others who are in slumber, to look around and see those who are suffering around them and contextualize the fact that justice is about looking at the person with whom you claim to be solidary. Bram Fisher said one thing, and this is to lawyers, because most of us who, when we were students, we were activists. Most universities have lost students as activists, but that activism hardly outlasts graduation because money takes over, power takes over, arrogance takes over. Bram Fisher said this about a lawyer when he was facing a court that said he was odd, probably like me, controversial, saying things that people think lawyers shouldn't say. He said this, I quote, "When an advocate does what I have done, his conduct is not determined by any disrespect for the law, nor because he hopes to benefit personally by any offense he may commit. On the contrary, it requires an act of will to overcome his deeply rooted respect of legality. And he takes the step only when he feels that, whatever the consequences to himself, his political conscience no longer permits him to do otherwise. He does it not out of a desire to be immoral, but because to act otherwise would, for him, be immoral," close quote. C.J. Langa seems to have been influenced a lot by Bram Fisher. I say this because I spent time with him. And he was a man that believed that if you suppress dissent, you suppress progress, you suppress justice. And in one of the lectures that he gave, and I'm happy he prepared it in one of those sessions where me and him would sit and watch Formula One. Believe it or not, we watched Formula One. And he would write for this lecture. And he was boasting in the lecture, and I use the word boasting loosely, about what has made him. And the lecture was called The Emperor's New Clothes. And he quotes Ken Saro-Wiwa about justice and about what commitment to justice means and how far it should be taken. And Ken Saro-Wiwa was a human rights activist killed by the Sani Abacha government for speaking out, not for taking up arms. And he said, "I have devoted my intellectual life and material resources, my very life, to a cause in which I have total belief, and from which I cannot be blackmailed or intimidated. I have no doubt at all about the ultimate success of my cause, no matter the trials and tribulations which I and those who believe with me may encounter on our journey. No imprisonment, no death can stop our ultimate victory." From this, close quote, C.J. Langa took strength to call himself a dissenter because he believed that it would propel us to justice. And I will tell you at the end what justice is and what we need to be done in this country of what I call rotten justice and dead bodies walking alive, sacrificing the future of their children. He says, sometimes the simplest act, this is Pius Langa now, sometimes the simplest act of dissent can change the course of history. Sometimes the dissenter is the lone voice of reason in the dark. There will be some who privately agree with a dissenter. Be it a Galileo, a Saro-Wiwa, a Rosa Parks, or a Moore. The value and courage of dissent comes in standing up and pronouncing the difficult view in public and taking the consequences. It is easy to believe in something like all of us do here. it is much more difficult to speak out. Close quote. He further refers to Solomon Ash, a social psychologist who did a study, extensive studies were made about black people, about Negroes, and how they think. There was a study at some point whether black people have a soul, because we're not human. And Solomon Ash made a conclusion about why most of you, not all, keep quiet about difficult things in a society for 30 pieces of silver. He says the tendency to conform and to keep quiet because you're protecting a job or money. He says, after his research, Solomon Ash, the conclusion is this: the tendency to conformity in our society is so strong that reasonably intelligent and well-meaning young people are willing to call white black, close quote. And I showed you the book about the death of truth, because justice cannot prevail if truth is the enemy. Justice does not prevail in a climate in which truth-telling is taboo. And Judge Langa concludes about dissent, that it is dissent that propels people, and it propelled Nadel, it propelled BLA, it protected Judge Desai and them in the unity movement. It is dissent that propelled them to do something. And as we sit comfortably today, because we're nursing jobs and things we have, it's going to take dissenters to prick our conscience. And so there's no doubt that post-apartheid South Africa emerged from injustice. That's the past. I don't have to dwell much on what injustice is, because injustice is the opposite of justice. And a lot of people say we are very emotional about this issue. I've heard people say, yeah, that's Kakani is a little emotional. If injustice doesn't make you emotional, you are not human. If justice is not an emotional issue to you, you are not human. And if you have not found something on earth for which you prepared to die, your life is not worth living. If you've not found something like justice to be a cause for which you could act without being paid, you're not human enough. And so our past, which is lack of justice, can only be complemented if we understand what the true nature of justice is. And what is the true nature of justice? Justice in the US, justice in Bolivia, justice in India and South Africa do not have the same context. And many liberals, and I'm about to offend judges here because I think South Africa calls itself a constitutional state, but we are not that. We are a liberal constitutionalist state, and that's why most of us as lawyers are unable to articulate anything else except liberal constitutionalism. We've not read the Bolivian constitution, which is great. We've not read the Indian constitution, which is great, because what we live in is what I call the act of constitutional borrowing from two countries, Canada and Germany. We actually have not seen how countries that have gone through settler colonial jurisprudence regard justice. And now here is justice for South Africa. What is its historical context? The historical context is what everybody has told you about here. Is injustice, is discrimination, is dispossession, and being told you are not human, which I call despiritualization. And so any other form of justice, my main theme today is to tell you that justice in the context of South Africa is a child of a broader philosophy called national liberation. Anything else outside that is not justice. if your interpretation of justice is not to reverse the vestiges of what most people suffered, you are not engaged in justice, you are engaged in law. And there's a difference between a court of law and a court of justice. We've not reached that debate in South Africa, but we will, because we lawyers are produced by liberal constitutions and institutions. And my message today is this: South Africa in the future will have justice if each one of us are prepared to call things by their names. I'm not being petty when I say there's a reason, there's cowardice involved in having a constitution that most of you call the best constitution in the world, that cannot mention the crime against humanity against which we are fighting. Not mentioned once. Apartheid is not mentioned once in the constitution. Settler colonialism is not mentioned once. And there's a reason. Many people say, do you want us to mention all atrocities? No. You can never solve a problem you are scared to pronounce. And the reason we don't pronounce the word apartheid and settler colonialism, and I'm sure it shocks you as I say it in this room, because you are engineered to fear anyone who offends white power. It's because we do not want to offend the very people that don't think we are human. The very people that did not grace this occasion because Judge Petse is black. The very people that think you and me are not human. And we are polite about it. And no justice, no national liberation, nothing will happen if you leave it in the hands of white magnanimity. No oppressor has ever given power to the oppressed free. And no one can achieve justice if inside them they have fear of the very hand that delivered injustice to them. And so injustice starts with the fact that as I speak now, you are uncomfortable. You are uncomfortable because I'm attacking the power that you saw when you were born around you. That was white, that was male, that was unjust, that was violent, and you fear it 60 years later. And if we must leave justice for our children, for the future of this country, it is that fear. If it's that spiritual vacuousness in us, the fear of something that dislikes us, and the hatred of something that is similar to us, and despising who we are, and all of those things are the opposite of justice. And justice is about fairness. Justice is about retribution. Justice is about distribution. And if you have not made atonement for what people went through, the system is not just. And if you are sitting in a court where you are comfortable with the laws that you found, and you've never analyzed what is the jurisprudential basis of the law you dispense, you have not even started to deal with justice. You are still perpetuating what you found. And lastly, if you have time, read the story told by Friedrich Nietzsche in 1881 if you want to know what to do. It's a story about the death of God. By Friedrich Nietzsche in 1881. I'm going to summarize it for you because it's about what I want you to do. Friedrich Nietzsche tells a terrible story of a madman in 1881. He says the madman walks around, goes to the market. And in this market, he finds people like you and me who believe they are normal. And the madman shouts at them. He says, "Whither is he? Where is he? Where is God? Did anyone see God? did he just disappear? And people mock him. They say, well, maybe God became like a little child, he disappeared. They mock him for a long time. And the madman jumps right in the middle of all of them, the normal people. He says, I ask you again for the last time, where is God? Did you kill God? And they don't answer, they mock him. And then he says to them, well, God is dead. God died by our hand, by our sword. We killed him. We are all murderers. These churches you've built are nothing but evil temples. You've trampled on them. You've desecrated the graves of the dead because you don't know what to do, because you don't know where you are, because you don't know what justice is. And he says to them, for as long as God is dead and you don't know what to do, you who are normal are not normal. For as long as you are comfortable with the death of God that you've killed. And what does that mean for those of you who didn't do literature? It simply means for as long as you are unperturbed by the person within the worst conditions around your life, you do not know justice and you do not like justice. Paulo Freire, as I close, tells us this about solidarity and justice. It's an old book, by the way, Put Russell, I was given by Mom Victoria Mkenge before she died, when she came to bury Matthew Koniwe. And this book by Paulo Freire articulates a couple of things about the pedagogy of the oppressed, what to unteach the oppressed and what to teach the oppressed to teach their children about justice. And he says somewhere about solidarity, which is the challenge I give to the judges, I give to each one of you, to myself, as we approach what I call the pinnacle, precarious stage of South African life. Because if we do nothing about what's happening today in South Africa, we're going to have 5 years, after 5 years, after 5 years, until all of you are 105. And he says solidarity and justice are very simple. Solidarity is placing yourself in the boots of the person with whom you are solidary. Solidarity is putting yourself in the boots of the person with whom you are solidary. Justice is putting yourself in the shoes of the person you despise most. It's putting yourself in the condition that you would never be in for one day, and dealing with it is the opposite of injustice. And justice is fairness, justice is total human emancipation, and justice is empathy with those around you. And if our courts are that, if we are that, our families are that, justice will prevail. We are far from it for as long as the surroundings are what they are. And I'm challenging that we must think about this, whether we have courts of law or courts of justice. And we can never agree about justice, democracy, and human rights for two reasons. One, human rights, we can never agree for as long as we don't agree who's human. Democracy is about people's government by the people for the people. It can never happen in a country where we've not agreed about who is a person. And justice cannot prevail if we've not agreed about who is a person, who has a soul, who's human, and who deserves justice. And as I've always said, the test that you are a just person is how you deal with those you don't like, not the ones you like, because they always get justice from you. How do you deal with those who are hated by powerful classes in society? That's what Langa was. That's what I saw in Judge Petse in court. I was not asking for a revolutionary. I'm asking for a good person who's just, who's a human being. And I'm very proud that the judges I see here, I don't miss the ones that chose not to come. Because I have had serious engagements with Judge Poyo Dlwati for the whole week. Serious engagement. She was right on my case, but I was comfortable. It was intellectual because I was debating with someone who sees me as human. I've had the same with Judge Mbenenge, Putokota, and everybody. And that's what justice is about. And one day, maybe not now, when we've become completely intolerant of watching others suffer, we will love justice and we will defy laws that do not ensure liberation because they are unjust. Thank you.
Wow. Thank you very much, Advocate Skakane SC, for this mouthful presentation you have made, which is, of course, thought-provoking. Who is a person? It's a question that we must ask ourselves every day when we go to court, when we sit in the benches. When you act President Nokesi, you must ask yourself, who is a person? I think maybe a person, Justice Boyo, is a person who is able to host candidate attorneys to his house when they write board examinations, like he once did to us. I don't know whether you were already a judge at the time, but you hosted us. We have no place to sleep. We're coming from Tata to write in Pietermaritzburg. Fortunately, or unfortunately, Mr. Nokesi just left because we had to flee away from home because there was a serious bottlenecking and gatekeeping. We have to go to write in KZN. Those are the things that we need to talk about, as Advocate Skakane, as she said. Obviously, some of the things, when we raise them, we become even ourselves very uncomfortable about, because, thank you very much, thank you, Buti, because they will be received negatively by the people whom they are directed to. I just want to take a few hands, a minute to a person, and I cut you. If you are going to talk for a long time, no introductions, no preamble. Anyone who wants to react from the past, the future, and the present. I always make reference of the present as the last one, because we are confronted by serious problems today. Can someone assist me with roving mics? Okay, thank you very much. Advocate Maga, you are going to be the first one. And then Advocate Mfeya, you are the second one. I'm going to give you, comrades, 1 minute, 1 minute. You are going to be the last one. My sister there at the back. I'm happy there is a female. Thank you very much, Advocate Maga, you are recognized.
No, thank you, program facilitator. I could listen to Butmuzi for the whole day. We always say that as my friend, with my friends. My question is more of an input and a concern, and I wish we could get some guidance from Butmuzi and Justice Madlanga. we, as the prosecution, see ourselves as partners, very important one and integral part of the justice system broadly. Central to the input by Justice Madlanga was the role of a prosecutor then, who was fearless gunman. Can we have the same fearless gunman as a prosecutor with the current crop of prosecutors that we have in the NPA? And what is it that we can do to get that? Secondly, the NPA or the prosecutors seem to be very aloof from the entire legal profession or practitioners. As a result, are seen as opponents, autonomous, and all of that. How can we bring them closer to the entire criminal and justice system broadly, so that when we speak with one voice? It's only me and Woodbury here, but it would have been nice to have those prosecutors as part of these sessions as well. So my question is two-pronged. You can see how to bring it all home. Thank you very much.
Thank you. Advocate Mfeya. There are other prosecutors up there. Hope I am not disclosing from the employer, because the employer is here. It's during office time, office hours, supposed to be in office. Advocate Mfeya is the gentleman with the blue suits. I wish to answer this question, what you need to do at NPA. Train prosecutors not to look for convictions, but to ensure there is justice.
Thank you, program facilitator. Mine is also two-pronged. It's first a comment, then it will then be a question to both the panelists. Firstly, the second panelist states that our constitution, and correctly so, that we live in a constitutional democracy today. And many of us, when we take our oath, we swear to the very same constitution. And I agree with him that in somehow it is a liberal constitution. But one can say that at least in the past 30 years or so of our democracy, the Constitutional Court has made a lot of landmark cases in as far as human rights are concerned. But now, one would defend it in the sense that, because you will also hear in the corridors that our constitution is a living organism. In other words, that it is upon Justice Madlanga and the others in the Constitutional Court to give our constitution that living organism in it. So the question then, therefore, I will ask is our constitution indeed a living organism? Because when one looks at the judgments that are prevalent, more so in the socio-economic judgments that you will see, our courts seem to be lacking in emphasizing on the socio-economic aspect of our constitution. For just to, as a brief example, before you come off, Parliament facilitator, you would look at your mere small cases as evictions, so on and so forth, whereby the Act and also the Constitution says that it must be just and equitable to do so. But if one just meets the jurisdictional requirements of eviction, one is evicted. So but the question therefore is our constitution a living organism or not? Thank you.
Thank you very much, Advocate Mfeya. Where is the last one there at the back? And then we give over to the panelists, the past, the present, and the future. Over to you, my sister.
Thank you very much. Mine is not much, it's to appreciate and to show gratitude, and also just to give a suggestion and raise something, an awareness of some sort. Firstly, I would like to appreciate this initiative and whoever came with the thought that we need to appreciate Judge Madlanga. He has done a lot. The work that Justice has done is a lot, it's humongous. And looking at where we are now, I would like us to just, looking at where we are now, I would like to just reflect and see, because I just heard Mr. Dia speaking that in his time there was a gatekeeping system. That gatekeeping system has not gone anywhere, it is still there. For someone to leave your province to go to another province to become what you aspire to become, I believe that Nadel should stand in that gap and be able to assist us when it comes to that. But apart from that, I'm looking at a vision whereby Nadel is clearly bringing up leaders that make a great difference. And I would like us to go broad, go deeper, go to universities, but raise them while they are still young, identify them from schools, because clearly Nadel is capable of doing that. We can see now from the one who's currently taking leave. So we need more leaders, and I appreciate everything that Nadel is doing, but can we do more?
Thank you very much, my sister. Those are the few questions and comments that you have to respond to. But also, on this breadth of claiming, there is Mr. Lusu in our midst, who is coming from Libote like me. He's, we are also both Anglicans. Hey, there are many Anglicans here. But we'll discuss later this issue of the death of God. Thank you. Over to you, Ras.
Let me start by responding to the second question. I'm not as comfortable as you were in describing him as being in a blue suit, but I think I've just done so. Anyway, you asked whether the Constitution is a living organism, and you seemed, in a sense, to be directing yourself to the courts. My response would be, the role is not only that of courts. Courts deal with matters, let me loosely say, on an ad hoc basis. I say ad hoc basis in the sense that they can only adjudicate matters that are brought to them. Otherwise, if it were not for the huge numbers of matters that sit before us, we would sit twiddling our thumbs, waiting for each ad hoc matter to come to us. So the other role players are you, the lawyers. You must make sure that you bring matters that will enliven the Constitution. You bring those to us as a court, or as courts in plural, and we as courts will then attempt to do the best we can within the parameters of the Constitution. And I closed off by saying that we do not live in a perfect world. If I were to just say a little bit more on that, for as long as we have organizations like Abahlali Basemjondolo, for as long as we have organizations like Ndifuna, is it Ukwazi or Ulwazi? For as long as we have organizations like SERI, and for as long as those organizations have causes to fight for, and I believe they do, by the same token, surely there are causes that lawyers must also fight for, because the causes that these organizations fight for are largely court-going matters. So to make the Constitution a living organism, all of us, the affected players, which include you, must each play our role. The Constitution is not a self-executing document. There is nothing it can do lying there. So it requires actors to do something about it. And Mtunzi, if I were briefly to just touch on, I will leave the question about aloofness to Muzi. And I'm by no means saying that he cannot add responses even where I have responded. But on the one about the prosecution continuing today to be a gunman, I would say there is no need at all to be a gunman. A prosecutor is doing prosecutorial services for the attainment of justice.
and Muzi explained to us what justice means. Once you approach that task with the mindset of a gunman, I just do not see how you can ever truly be seeking to attain justice. So for me, short answer, no need to be a gunman at all. Thank you.
Thank you. Advocate Mahaga talks about what do we need to be fearless, to create fearless prosecutors. You know, this does not need training. In South Africa, we emphasize training because we are avoiding being courageous. I think what we need, Mthunzu, is the ability for people who are in state institutions, the judiciary, SARS, the Reserve Bank, the president, the legislature, and everybody to grow a little bit of spine. It won't take long, it doesn't need training. It requires people not to serve ruling elites in whatever position they have. And if you do, to question yourself as you check the mirror every morning. Don't check the physical part only about how beautiful you are. Check whether are you sufficiently courageous to face the world on behalf of others every morning. And if prosecutors did not become tools of ruling elites, but prosecuted without fear or favor, that's all they need. They need no training. They need to be told that courage is not the absence of fear, but the dominance of love for society. I thought Mthunzi, and the other gentleman, I must close for you with something only women know. Because national liberation, justice, and all of those things are like childbirth. And only women can tell you what childbirth is, pre-childbirth and post-childbirth. And new countries require that. And Friedrich Nietzsche says this about what we should be, even about what you say courts are. He says, I quote, unless you have chaos inside you, and that's why I said only women know this, the chaos before childbirth. Unless you have chaos inside you, you cannot give birth to a dancing star. It means unless you can confront the upheaval head on, something new cannot come. I was listening now when you're speaking to Judge and all of us, and I think here are Africans sitting in a room discussing law with limits. We are unable to imagine that even the legal culture we are talking about is inherited. We have not even begun to contextualize what would we have as Africans if Western modernity had not taught us Roman Dutch law. Were we slaves? Did we not have laws? Chairperson of Magwanisha is here. A very good friend of mine and chairperson of the Justice Portfolio Committee, probably the best we've had so far, phoned me one day and said, hey, Comrade Muzi, you must help us with the traditional courts bill. It's very progressive. I listened to him, he will attest. I asked him this question very politely. Why do you call it traditional? Traditional as opposed to what? How can an African in his continent call something he must do traditional? It means what is Western is norm to you. And so we need those debates. And I think about what you were saying, we need those debates. We need to look at what we do. Our courts cannot do more than they do. But of course, we can rethink what a court is. I think a court of justice is something we have not seen. We have great judges. We have a good court, well-meaning judges. But philosophically, we are stuck in the court, in the concept of the court as we inherited it. We've not even been trained to think outside what we've been told. A court can be something different than what we see now. And Langa, I do think a court, by the way, we can think of a society in which a court does deal with disputes, but also a court can decide that this country has strayed or these people have strayed. I'm not saying we have many courts like that, but we are free to think differently. Because if we are not thinking differently, we've not broken the chains that tie us to what we didn't like. Thanks.
Thank you very much, ladies and gentlemen. I invite you, Advocate Skakane, to watch the drama called Ityala Lamawele, and you would see maybe the type of a court that the Director General was talking about. Thank you very much for being a wonderful audience, even the judges. I was expecting that they will want to say something on this element of a judge should be a human being. Back in the days when I was very new in the profession, there was an ADJP here in Mthatha. If it's him on the motion court on Thursday, all advocates would be standing next to the door giving us our briefs because they don't want to appear before that particular ADJP. Then it became a problem and a norm that we know as attorneys that if that ADJP is going to be the duty judge, we simply file a notice of removal. Notice of withdrawal, because we know the advocates will run and you will be angry and there will be chaos in the motion court. We do not want those type of judges. We want judges that Advocate Skakane was talking about, human beings. People that we can converse with, people we can share stories about the society, people that we can share our views about the rape cases that come to court from So What and Highness, where when we look at there was no rape, but this one was supposed to pay, he didn't pay, so that when you adjudicate, you have a clear view of what is going on in the society. You don't have only a perspective of an adult person who does not go to clubs, so that you know what is happening in the society. But if you are judges that we fear, that we cannot talk to, you will not know these things. And on the ground, we'll be criticizing you. When we criticize you, Moelet Mpeki once taught us of the Tunisia Day. That Tunisia Day may be closer, and we rebel and we say away with justice, and we will not want to go to courts, we will chase police and everyone. But if we have that particular relationship between us and yourselves, then it would be better. On those words, I want to thank you very much, all of you. Everyone has been speaking here, referring to Brady. Brady is Brady even to us. I was doing his case at LPC. I cross-examined him. He said, I got in. So when Busa was needs man up, I want us to arrive at a decision. Ingabufuna se igqotha le junior. Nobufuna sithini. I knew that akazuvuma. Otherwise, it has been a great day to have all of you here. Thank you very much for being a wonderful audience. We will read your books, The Death of Truth, and the one by Bram Fischer, Frederick Nietzsche. Thank you very much for Lomkhabolo on the past and the present. And this past, we recordile Advocate Marga, so that even your staff now, Mr. Madolo, so that they know what type of prosecutors are we looking for. Otherwise, if we're looking for, I said this even in the Papasa launch, after we made submissions that we must stop suing NPA. I said we are going to stop suing NPA after NPA has stopped malicious prosecution. Every time they do malicious prosecution, we write presentations on clear cases to your department. They got rejected. They say, no, let's go to court. We go to court, found guilty. On appeal, we get away with the appeal, we sue. And when we uplift that letter and say that we told them that they don't have a case, and then Judge Olwana will say, they must pay. Thank you, Judge Olwana. Thank you, everyone.